Our special guest we have in the studio, criminal defense attorney Michael Bixon. Okay, Michael, best guess, what do you think is going to happen after this lunch break? Is he going to come with that list the judge wants him to come with, or is he just going to say, oh, it's just me, judge, and I'm going to tell my story?
There might be a list. There might be some names on the list, whether or not that has any real, relationship to reality. Who knows? I mean, he might, whatever he's going to scribble down there. I mean, look, it came as a surprise to his defense attorneys, and I think it's for a reason, because he enjoys the chaos and confusion. Maybe he's trying to create some appellate issues. Maybe he just likes being in charge. It's really hard to say. But I doubt that if he actually does come up with a list, that it's going to be anything substantive. So.
Right. And what if, let's say he does come up with this list, and let's say there are actual individuals who could provide some worthwhile testimony that would be relevant and acceptable, in this kind of the penalty phase of the case. But let's say they're not available today. I mean, people have lives, people have jobs, families, they may be in a different location. What happens then to this case?
Well, this is part of the problem, right? I mean, this is not a case that happened overnight. He's had ample opportunity and time to prepare and allow most importantly, his attorneys to know who these people are and to call them, to subpoena them, to make sure they appear. So if all of a sudden at the last minute he's saying, oh, I have these people that should come in and testify and they're absolutely essential to the case, why didn't he let them know beforehand? He absolutely could have. It's not like he didn't have an opportunity to meet with them and talk to them. So this is something that should have been done before. I think that there is a chance that the judge could continue it if they were absolutely essential. I just think that chance is very, very minimal at this point.
Mm-hmm. Is it a delay tactic? I mean, do you think this is all a lie to delay?
Honestly, I think it's one of two. It's either one, to delay it, or just because he enjoys being in charge and in control. And if he can set this trial off, make it delayed, and just, be the one up there grandstanding and controlling everything, he's that much happier. It could be either one. But I don't think that this has any real rational relationship to his actual defense.
Right. And he has been really adamant in that conversation with the judge, which happened outside the presence of the jury. He was really adamant about how he's so honest. He told the court at one moment, it was kind of laughable. He said, I'm the most honest man I've ever met in prison. You met yourself in prison. Okay. But he said he's the most honest man, and he wants the court to know he has honest things to say when he takes the stand. Let's take a look back at the clip now, and we'll talk about it on the other side.
Any other witnesses, any other evidence of any kind, and evidence means anything that you can think of, basically. Photographs, audio recording, video recording, fingerprints, anything at all.
Well, yeah, in fact, yeah. I mean, all this discussion about, proof and my credibility within the Federal Bureau of Prisons as being an inmate, pound for pound, I'm probably the most honest inmate that I've ever met in my 25 years in the Bureau. I can back it up with filed lawsuits. Everything's gone to summary judgment. I've never filed anything. I've filed many administrative remedies. I mean, pound for pound, I'm a very honest person. What I say, I can prove. Anything that comes out of my mouth, I can prove.
Mr. Nels, I hear what you're saying, but I don't understand if that's an answer to my question. I'm thinking, other than what you may testify to, are you referring to some other evidence that you think should be introduced during your penalty phase other than your testimony?
I'm sorry, I got off the track there just for a second, Your Honor. Well, there is a lot of things from United States Senator Bernie Sanders that I went through his office for congressional inquiries for over a decade, from 96 to 2016 or 17. And he wouldn't waste his time with someone that was dishonest. So, I mean, there is those records. I mean,
what records are you referring to?
Well, the records from his office for congressional inquiries. I mean, he's made at least, with no exaggeration, 24 or more.
So he's trying to bring Bernie Sanders into this. Michael, go.
Look, about 9/10 of what I just heard was absolute garbage. I mean,
Right.
Let's be honest, right?
Right.
The only shred of anything in there that I think might actually be realistic and might actually help him is if maybe he were to subpoena maybe some of the guards who could say that, he had snitched on other people in prison and how reliable and trustworthy he was about telling the truth to them. But even then, even if that is the case, this is something that should have happened a very, very long time ago. And he's the one who's been pushing this to trial. He's the one who wanted this thing set in advance, not his lawyers. So at this point, it's on him, I think, that this wasn't made, they weren't made aware of it beforehand. But the rest of it about Bernie Sanders, forget it.
Come on.
It's nonsense.
It is nonsense.
Yeah.
To your point about the trial and the delays, let's watch this clip now. And this is what Nelson had to say about that.
And in terms of, to the extent you seem to be referring to corroboration, is there some other than yourself, is there some other witness that you think should be called to testify to corroborate anything you just said, corroborate anything any of the other witnesses have said, corroborate anything else that's in any of the documents that have been put into the evidence by the defense?
I believe there are, sir, but I'm not going to delay the trial. I'm just going to let it go as it is. I would like to testify.
He's not going to delay the trial. Well, that's an interesting statement, isn't it? Because all of a sudden, he's going to take this lunch break and come up with a laundry list of people to present to the court. What did you think about that statement, Michael?
To me, honestly, what he's doing, I think, is setting up some appellate issues. He's saying, oh, there are these people out there that could have come in and, yeah, they could have helped, and I think that they might have done something for the case, but it's okay. Now it's sort of almost on his lawyers. Why didn't you bring them in? Why weren't they here? If they could have helped them, they could have done something. Whenever you're dealing with a case as serious, especially with, a death penalty case, every little avenue, every little alley of defense should be explored. And so if he tries to bring this up on appeal saying, oh, well, there were these people that could have helped, but my lawyers didn't bring them in, and, I just thought that they weren't maybe necessary, maybe it's something for him on appeal. But realistically, I think it's utter nonsense.
I agree with you. You make a great point. He's trying to set up issues for down the road. He fancies himself as a jailhouse lawyer. He loves to write motions, talk about how he spends much of his time in the law library and he seems to have that attitude like he's smarter than everyone and a very arrogant attitude. I thought so during the guilt phase. Did you when he was up there?
He thinks he's Perry Mason in there.
Right.
He's running this show.
Mm-hmm.
When he takes the stand, it's all about him. And we hear him over and over and over how badly he wants to take the stand, how badly he wants, no matter how good or bad it is for his case, he wants to get up there and talk. So, this is an ego issue. It has nothing to do with him being good or bad with the law. It's pure ego at this point.
Absolutely. The one for notoriety and infamy, and he knows, the time is, the days are numbered here. He's in prison. He's going to stay in prison or go to death row and leave the earth. So we shall see. All right, Michael Bixon, it's always great having your thoughts. You're going to stay with us as we're waiting for the jury to come back from recess. We've got our crew there in the courtroom waiting for things to pick up. This could be it, folks, this afternoon. Will Scott Nelson take the stand in the penalty phase of his trial? Back after this break. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us on this Monday afternoon. Folks, court is expected to resume at any moment in the penalty phase of the trial against Scott Edward Nelson. He's already been convicted of the brutal killing of beloved nanny Jennifer Lynn Fulford. Now, the state is seeking the death penalty against him. And we should find out very shortly whether or not Nelson will take the stand again. He did during the guilt phase. Now he might do it again in the penalty phase. And this morning, his attorneys asked the judge if Nelson could make what's called an allocution statement. And this is something where he would just address the court without being sworn in as a witness or subjecting himself to any cross-examination by the prosecution. And of course, the judge said, no, that's impermissible. We're not going to allow that. You can testify if you would like. That is his right. So he's going to be thinking about that during this lunch break and also supposedly coming up with a list of witnesses that could be called to testify on his behalf as part of the mitigation that they're trying to present in the penalty phase. So we're going to find out if that's the case, if he comes with a list of witnesses. They've had a long lunch break. They're going to be back around 1:30. What I want to do right now is give you a look at some of the musings from Scott Nelson this morning in court.
As far as the prison rape, I was beaten and raped, and the staff allowed this to happen. They allowed me to walk around general population with a black eye so bad that it was completely swole shut, 100% swole shut. Lieutenants, everybody stopped me. Hey, buddy, come here. What is?
Mr. Nelson,
Okay.
you mentioned as far as this, you just stated the way you phrased it as beaten and raped.
Right.
Are you saying there has been evidence solicited from some of the defense witnesses, and some certain things are referenced in some of the records? What are you saying? Are you saying there's some other record that provides proof that you were beaten and raped that is not part of what's in evidence now?
Well, I think what it comes down to, Your Honor, is the fact that, I'm being truthful, and a lot of things try to get pushed under the rug by the Bureau. And I'm just saying that anything that I say shouldn't be just brushed off like I'm some impulsive liar or some embellishments or something. I can prove what I'm saying.
Oh, and he may want to this afternoon. I want to turn to my special guest in the studio, criminal defense attorney Michael Bixon. Okay, Michael, what do you make of what we just saw in that clip?
Nonsense. I mean, again, just it was terrible. I can imagine if I was his attorney, I would just be writing over and over on the piece of paper I had in front of me, please stop,
Right.
please stop, because it does nothing to help. And I understand that a part of what he's saying is going to help him, right? But it's nothing that they haven't already explored. The only thing that they haven't are these witnesses that he's all of a sudden brought up out of nowhere that maybe they can. And again, that's on him for not telling his lawyers earlier.
Absolutely. This legal team, I have to say, and I'd like to get your take because you practice criminal defense regularly, they have really impressed me on how they have handled him, his combativeness, his insults, his demands, antics, delaying the start of the trial, throwing fits, the meltdowns, all of it. This team, they deserve a medal for what they're doing with him in this case.
Yeah, I mean, look, they are doing their best to work with him. And it's hard because he keeps trying to almost sabotage his case by getting his grandstanding in, by getting his testimony in. And look, that's totally his right if he wants to testify. There's nothing wrong with that. But you should listen to the advice of your lawyers. And if it's going to hurt your case, it probably isn't a great idea to do that. Now, on the death penalty phase, I think that there are some things that he can say at this point that can help him. But how he says them and like these outbursts in court are not going to help him in the slightest.
Absolutely. I believe we have another clip in where the judge is talking about producing that list actually before they return from the lunch break. So the jury is supposed to come back in the courtroom around 1:30. Let's take a look back at that now, and then we'll discuss.
I can think of one right off my head. Lieutenant Grieve. Lieutenant Grieve, he works for the Federal Bureau of Prisons. I'm sorry, I don't know his name. His last place he was employed in the year.
Lieutenant Grieve?
Grieve, Grieve.
Okay.
Lieutenant Grieve in United States Penitentiary, Lee County, Virginia.
Anyone else that you can identify?
I would have to have a couple minutes with a pen and paper over lunch, and I could come up with a list. These names will pop right in my head. I'm just saying that these individuals would corroborate everything I'm saying.
Any other witnesses that you can think of in terms of their names that you have right here that you can tell me?
I'm weighing them all out. I need a few minutes to get my mind together, sir.
Okay.
Put them together. I promise you I can come up with several names. Just it would take me a moment. I'm like under the gun, if you will.
All right. So here's what we're going to do. We're going to take our lunch recess in a moment. During the lunch recess, Mr. Nelson, you need to get this list together of witnesses. You need to compile a list of any other exhibits, documents, or any other evidence that you believe, other than your own testimony, that you believe should be presented. Because when we come back, and then you need to get that together ASAP. You need to talk with your attorneys about it.
Yep.
And then when we come back, we can talk about that.
Yep.
And then after we've talked about all that, then we will go forward and talk about whether you're going to testify. And you can also talk with your attorneys during lunch in view of what you've already presented, in view of this additional information that you'll be providing your attorneys for the very first time. Talk about all of that, and then we can have a discussion when we come back from lunch.
Okay, Your Honor.
All right, so let's give Nelson the benefit of the doubt here. Michael, he's saying he wants to call these witnesses to corroborate what he says were beatings and rapes when he spent all that time in prison. We know he did 19 years in solitary. We know he had problems with snitching, whatnot. he's saying that these witnesses could help corroborate that, and those are supposedly some mitigating factors in this penalty phase. Does he have a valid point with wanting to bring in these witnesses?
I think if they do exist, he absolutely does. The issue is this is not something that happened yesterday or last week or even last month. This is over a long course of him being in the federal prison system. He knew about this. He should have told his lawyers. I mean, I think Judge White has shown an outstanding, I guess, ability to deal with these issues as, as they've come up. If I were him, I mean, there was a good chance that he could just said no, just outright no, forget about it, you had time. But he's actually allowing him the opportunity to even write down this list and maybe even contact these people. And I think it's remarkable that he's shown that much restraint in this case already and allowing him to do that. Because this is so outside the norm of how things are done. A case like this is prepared months, maybe even years in advance.
Right.
And now he's saying in the middle of the death penalty phase, oh, I have these people and they can help. And maybe we want to call them in. I mean, most judges just, they just say, it's too late. So sorry. That's it.
Right. Good point. I agree with you. I think Judge White has handled this exceptionally well, and probably because he's cognizant of the fact that we don't want anything coming back on appeal. And, to your point about he's known about this for months, with a death penalty case, there's notice at the outset of what the prosecution is seeking. So talk to me about that, he's going to be on notice from the time that they made that decision, right?
It's been a minute. And that's what I've been saying. He's known this for a while now. And if they knew, look, this case from the get-go was not about whether or not he was innocent or guilty. It's about whether or not he was getting life or the death penalty. And they should have been preparing from day one. Let me rephrase that. He should have been preparing from day one because his lawyers have done a fine job throughout this trial, especially with handling him as a client. And this is something that if he wanted explored and these people brought in or subpoenaed, he should have let them know beforehand. But this is insane to try to bring them in halfway through the death penalty phase.
Can't wait to see what happens in just a couple of minutes. Michael, you're going to stay with us. We're so thankful for that. We want you to stay with us at home. We're so grateful for your company today here on Court TV Live. Court is set to resume at any moment in Orlando, Florida. We're going to take you inside that courtroom as soon as it does, as we continue our coverage of the state of Florida versus Scott Nelson. Will he testify? We'll find out after this.
Tonight on Court TV.
We will be live in Orlando for week 3 of our gavel-to-gavel coverage of the nanny abduction and murder trial.
There hasn't, in fact, been any attempts for intervention or treatment.
It's the ultimate decision for this jury. What will happen to Scott Nelson? Life in prison or a trip to death row? We're live in Orlando breaking down today's biggest moments.
Closing Arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
You are watching Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us on this Monday afternoon. Court is set to start at any moment in Orange County. This is Orlando, Florida, where we're in the penalty phase of the trial against Scott Edward Nelson. There's a look at the seal in the courtroom. We've got our camera pointed there because the jury is out of the room right now. We are watching the courtroom. We've got our crew there. As soon as things pick back up, we're going to take you in there live. For now, what I want to do is turn back to our special guest here in the studio. I have with me criminal defense attorney Michael Bixon. Okay, Michael, great to have you here and hear all your thoughts on this. I want to talk about his defense team and what they may be doing as a practical matter. When we heard what we heard this morning, him saying, I want to testify, and oh, by the way, I'm going to work on a list of witnesses I also want to call for mitigation purposes. And at this point, they've presented what they wanted to present. There are no more witnesses besides Scott Nelson from their standpoint. But so if you're one of his attorneys, what are you doing right now to kind of make things run smoothly, plan things so that this doesn't come back on appeal?
So usually the kind of conference that was had between Mr. Nelson and the judge wouldn't happen, right? Usually the judge would tell the attorneys, look, you speak to Mr. Nelson, then you can come and we can have this conversation between us, because there's an obvious danger for Mr. Nelson or for any represented party to have that kind of talk with the judge, especially in the middle of a death penalty phase. I was a little bit surprised that he even let it go that far, but we've seen how much Mr. Nelson wants to control this trial. And how much he wants to have his voice heard. So I'm not shocked that I think the judge understood that reality, that it was going to be that much more difficult to try to get it through the attorneys and not through Mr. Nelson. With that being said, it's hard to say how much of this is going to affect going on in terms of whether or not they're actually going to be able to bring these people in and whether or not they're actually going to testify, whether or not they even exist. But I think that his attorneys are going to do their job. They're going to try to find out if these people are there, if they can bring anyone in who can actually testify for him, maybe help his case.
Right. And we just got word, I just want to let you know at home, that the judge is on the bench, but nothing is happening yet in the courtroom. We've got our crew there, eyes there, they're communicating with us. And as soon as things get underway, we're going to go in live and let you listen in live. But right now, the jury is not in the box yet. They've been on their lunch break. And all of that back and forth between Scott Nelson and the judge happened outside of the presence of the jury. They were already taken back to lunch when he had that banter. And you're right, it is unusual. And he's just such a live wire, loose cannon. His team doesn't know what's going to come out of his mouth next. And I hear they're starting things up. Let's watch.
Ms. Simmons, is the bench ready to proceed? Yes, Your Honor. Mr. Nelson, are you ready?
Yes, Your Honor.
Mr. Nunley, state.
Yes, Your Honor.
All right, Mr. Nelson, did you have a chance to talk with your attorneys regarding all the issues we discussed before our lunch recess?
Yes, I have, Your Honor.
Okay. And were you able to identify any other witnesses other than the Lieutenant Grieve that you had mentioned?
Yes, just one, Your Honor. His name is, he's a warden in the Federal Bureau of Prisons. His name is Terry O'Brien. He would corroborate virtually everything I've ever said, without, of course, putting himself in jeopardy.
Terry O'Brien?
Yes, sir.
Right. Any other witnesses that you identified?
No, Your Honor.
And with respect to Mr. O'Brien and Lieutenant Grieve, did you provide these names, one or both of those names, to any of your attorneys and any contact information so they would be able to try to reach out and make contact with them?
Not that I recall, unless if they remember. I don't recall mentioning it to them.
Okay. Why are you mentioning it now? Why didn't you mention it to them earlier if you think they're important enough to call during your case?
Well, but I just assumed that I would be taken for face value and not tried to be construed as an embellisher or a liar or whatever, things of that nature. That never dawned on me. I just figured that, BOP memos, documentation that's, Freedom of Information Act that they could have acquired, I figured that that would all come out to fruition. I wasn't, everything I've ever told the court or my attorneys is 100% truthful.
You mentioned the Freedom of Information Act. Did you ask your attorneys to try to obtain documents related to these witnesses?
They've acquired a lot of BOP records. What in its entirety, I don't know what they have accumulated or been informed of. I only know a small part of it. I mean, I don't expect them to. I'm only allowed so much paper anyway in the jail situation. So, I mean, I don't know what they know or what they have.
All right. And so did you have an opportunity to talk with your attorneys about trying to call Terry O'Brien or Lieutenant Grieve or both?
I don't know what their stand is on it, but whatever they say, I'm willing to go with. If they're willing to forego it all, fine with me.
Well, have you had a chance to talk with them about what options you may have regarding these witnesses?
Would you like to know? I would like to go on with the trial without any delay, Your Honor, rather than have Warden Terry O'Brien in a delay in the trial for continuance, et cetera, et cetera. I think it would not be in the interest of justice. I really don't believe it would be. Because what he's going to tell you is basically everything I've already said or has been presented before the court. And if he does put any credence to it, I mean, to what avail? I mean, I think in the general scheme of things, I think it would be just that we go forward without the interactions of the Federal Bureau of Prisons.
And I don't want to make assumptions, but from what you just told me, are you saying that Terry O'Brien, Lieutenant Grieve, they're not present in the courtroom or outside waiting to come in and testify?
That's correct.
Do you know where they are physically located at this time?
Not a clue.
Neither one of them?
Neither one of them. They're still employed for the Federal Bureau of Prisons somewhere in the system. Could be anywhere, California.
Do you have any contact information for them whatsoever? Telephone number, address, email, anything?
No, but they could easily be located, but, still to what avail? They have them.
And as you sit here today, do you know where they are? You said they're somewhere in the system. Do you have any idea what facility they're assigned?
Oh, no, not at all, sir.
Ms. Simmons, has the defense done any investigation or been able to do any investigation? I understand you just found out about these witnesses moments ago, but do you have any idea where either Lieutenant Grieve or Terry O'Brien are located, whether they are employed still by the Federal Bureau of Prisons?
No, Your Honor, I don't have any information.
Okay.
Sorry.
All right. And Ms. Simmons, have you had a chance to talk with your client about what would be required in order for the defense to attempt to locate Lieutenant Grieve, Terry O'Brien, in order to find out what they may have to testify to that would be relevant to this case?
Your Honor, we spoke about the options at this point. I don't have any information to locate witnesses or how to go out subpoenaing a federal employee, aside from my experience previously. But we've discussed with Mr. Nelson what would be required of us if we wanted these people to appear. And as he informed the court, he indicated that he didn't want to delay the trial. So we have not.
So you discussed with Mr. Nelson the option of moving for a continuance.
Yes.
Is that correct, Mr. Nelson?
That is correct, and I would prefer not to.
Do you need more time to talk to your attorneys about whether you want to move for a continuance?
No, Your Honor.
And do you need more time to think about whether you want to ask your attorneys to make a motion? I would obviously have to hear from the state, but just to have your attorneys make a motion for a continuance for the reasons that we've discussed regarding Lieutenant Grieve and Terry O'Brien.
I'd like to proceed forward without their interactions with the court.
Okay? And then with respect to, I'd also asked you to think about and talk with your attorneys about any other evidence other than these witnesses, other than your testimony, any other evidence, documents, DNA, photographs, any other evidence of any kind you thought you needed to think about it before you could tell me whether you were aware of the existence of any such evidence that should be presented during the defense case.
I'm not aware of any, Your Honor.
All right, and with respect to your testimony, again, like in the first phase of the trial, you understand that the jury will be instructed on all the law that's applicable to this case. And as was the case in the first phase of the trial, the case would be the same here, and that is if you choose to exercise your right to not testify, the jury will be instructed. They are not to consider that. They can't hold that against you. They can't draw that inference of guilt from that. You understand that?
Yes, I do, Your Honor.
And you understand, as we discussed in the first phase of the trial, if you choose to testify, then they'll be instructed your testimony to be considered like the testimony of any other witness.
Yes, Your Honor.
And do you recall our conversation about if you take the stand, then your testimony might actually help the state meet its burden of proof? Do you understand that?
I understand that, Your Honor.
And you also understand that since the defense has presented a case and there is a burden of greater weight of the evidence for the jury to find the existence of mitigating factors, you're aware of that?
Yes.
Do you understand that if you take the stand, that you might hurt the defense case? You might lower the weight that the jury would give to the evidence, and although without your testimony they may find the burden has been met by the greater weight of the evidence, if you take the stand, that might change. and they might find you did not meet the burden of greater weight of the evidence with respect to any of the mitigating factors.
Yeah, I understand that, Your Honor.
And as I mentioned in the first phase of the trial, although the defense did not present evidence there other than your testimony, here you have presented expert testimony. You've heard that. You've been sitting here through the whole trial, correct?
Yes.
And you've heard many, if not all, of the defense witnesses have testified to a certain extent, some greater than others, but they've relied upon your reports, information provided by you. You understand that?
Yes.
And do you understand if you take the stand and the jury finds that you're someone who they just do not find credible, not only could they reject your testimony, but they could reject any other evidence to the extent it relies on your testimony or information provided by you in writing, verbally, or in any other manner. You understand that?
Yes, Your Honor.
And have you considered the fact of the result of the first phase of the trial, meaning you took the stand, and nevertheless, we don't know what the jury talked about, how they weighed various witnesses. We could never know that. But what we do know is you took the stand and they found you guilty as charged on all counts. Have you taken that into consideration in determining whether you're going to testify in this phase of the trial?
Yes, I have, Your Honor.
And do you understand that in the penalty phase, just as was the case in the first phase, you have to testify truthfully, you have to answer all the questions by your attorneys and the attorneys for the state truthfully? You understand that?
Yes, yes, I do, Your Honor.
And since now there's no dispute, you understand the fact that you are a convicted felon, that is something the jury, just on that fact alone, can reject all of your testimony. And that remains the case.
I understand, Your Honor.
Do you also understand that although the defense has presented a case, and so the state already has the right to present a rebuttal case in rebuttal of the evidence being presented, you understand that you may open the door for additional rebuttal evidence if you take the stand that otherwise the state would not have an opportunity to present?
Yeah, I do, Your Honor. Yes.
And do you understand that by the court denying the motion that Ms. Simmons argued earlier regarding your allocution, that I denied that motion? If you testify, you will be testifying as you did before, meaning not necessarily the same testimony, but you'll take the witness stand, you'll be sworn in, you'll be examined by your attorneys, and then the state will have the right to cross-examine you.
Yes.
And you understand that cross-examination may be of matters that you may not want to talk about, and it may not even be the purpose of you taking the stand, but nevertheless, you may have to answer those questions.
Yes.
All right, do you need more time to talk with your attorneys about whether you want to testify during this penalty phase of your trial?
No. No, Your Honor.
Do you need more time to think about whether you want to testify during the penalty phase of your trial?
No, Your Honor.
Do you want to testify during the penalty phase of your trial?
Yes, Your Honor.
All right. If we can bring Mr. Nelson up to the stand.
Yep. No. Okay. Sit down.
And as you recall, and unless there's an objection, so that Mr. Nelson is essentially doing what the other witnesses, he'll be sworn in standing up. He'll be standing when we bring the jury in, and then he can sit down. We go, let's just do a test, Mr. Nelson, to make sure nothing's changed with your restraints. I didn't hear anything. Defense counsel, do you want to position yourself a little closer to the stand just to make sure?
No, Judge, I didn't.
Okay. All right, so Mr. Nelson, if you, is your tie adjusted? I can't see it, is it, counsel? Okay. All right, if, sir, why don't you stand then so that I'm bringing the jury? All right, and who's going to be doing direct with Mr. Nelson? All right, Ms. Moore, is the defense ready to proceed? Mr. Nelson, are you ready to proceed?
Yes, sir.
And Mr. Nolly, are you doing cross-examination?
Yes, Judge.
Is state ready? All right. All right, let's bring the jury, please.
With his life on the line, Scott Nelson is taking the stand.
Jury's entering.
Good afternoon, members of the jury. Ms. Moore, does defense acknowledge the jury?
Yes, Judge.
Mr. Nelson?